I'm going to replace your chair.
Thank you. The one that doesn't squeak.
Thank you.
Not that we all had ADD before this meeting, but when you were sitting on that chair like that, we all had
Good. Yeah, I've been playing too much tennis with both knees, and I've just got to sit more. Yeah, on Monday morning, the Miami Board of Realtors had a Zoom call with the lead attorney for the Miami Board. There's been phone calls with the legal attorneys from NAR, from other places that we've been part of. Monday at the leadership call with Keller Williams, there was a great call with Mark Willis and Jason Abrams.
Yeah.
Get your information from the right sources. Stop listening to all of these people out there who just want to hear themselves being heard.
Yeah.
Because most of them don't have a clue what's going on.
Correct. They didn't have a clue about real estate beforehand, and now they're experts at it. So we're gonna jump in, but before we jump into what we need to prepare for, I wanted to go on a little bit of a history lesson. So, believe it or not, the MLS in some way, shape, or form, its concept has been around since the mid-1800s, which is why I put these guys in a bar sitting around playing cards on the screen, is because the first iteration of the MLS was really a bunch of people that got together in a town hall type setup and said, here's what I've got, what do you have, and how much will you pay me if I bring a buyer? And that was the first real iteration of what the MLS looked like in some way, shape, or form. And the research that I did shows that they can document that first meeting taking place somewhere actually in like the Southern California area in San Diego, before it even got to the Chicago area to become the National Association of Realtors. And they can date back a paper form of the MLS, or a book in book is a really loose term for when they can date it back to the year 1887, which is where a commission agreement form had been created with properties advertised by address and what people were willing to pay for them. And then it went into something that looked a little bit like this, which is an MLS book. But let's understand what the purpose of the MLS actually was. The purpose of the MLS, Richard, right? It had nothing to do with advertising your listings to clients directly. It had nothing to do with fancy pictures being online. It had nothing to do with anything other than an address being listed and an agreement to pay a commission to a cooperating broker being listed. That was the whole purpose of the MLS originally.
Was actually opposite of what you were just saying. And it's one of the reasons that we're kind of in the position we are now.
Yeah.
Realtors were always looked at as the keeper of all the knowledge.
Mm-hmm.
You know, before the internet, there was no way of getting
Correct.
information out to the public. So
Yeah.
these books, and how many of you have been in real estate more than 20 years? I mean, Joy would
I'm sorry,
know.
39.
You,
Okay, when I started selling real estate, contracts were 6 pages long.
That's it.
17 pages.
Correct.
we celebrated when we were able to tell other agents to fax us over a contract.
Yes.
And
Yes.
we celebrated our offices when the office got a plain paper fax instead of the old ones on the
Roll
roll.
one.
Right. But at that time, every week, 1 week you would get a blue book, 1 week it was a yellow book. There were books about that thick, and it had every listing in the MLS. And the purpose of it, as Scott said, was simply my way of telling you as another realtor what I have in the way of listings and how much I'm willing to co-broke it with you.
Yeah.
Now, I know you're going to go on to the sub-agency.
Yeah. So that's what it originally was the ability for people to communicate what they're willing to pay. And it was, if you look at this right here, it says this is for the exclusive use of multiple listing participants only. This was not a public-facing book. Now,
If we found an agent giving this book out to their clients, we'd
Yes.
shoot them.
we'll go back to this picture for that. That's the way that it all happened when Richard first got started in the industry. And so then changes happened in the industry and things started to change. 1993, I believe it was when there was an act called Beretta that took place. And what did that change for our industry, Richard?
Prior to that, basically as a listing agent, I represented the seller. All the rest of you were sub-agents. That was how it worked. You were a sub-agent of the listing agent. That meant that legally, you are also representing the seller. So you're working with a buyer. That buyer's in your car for weeks at a time as you're showing them everything, and they're telling you their life history. You're finding out everything there is about that buyer, and your duty was to tell the seller. Meaning the buyers had no representation.
It's kind of like being a spy.
That's what, and talk about the public having no clue as to how realtors were working. That's what this lawsuit was about. So in 1993, with that lawsuit, all of the boards all over the country started making changes. And what happened was you all became dual agents.
And in 1993, when that went into place, Richard, agents crapped their pants and said, "Oh no, what are we going to do?" Right?
It's a change.
Yeah,
how are we
exactly,
going to work? How are we going to explain this to people? What are we going to do next? How can we be a dual agent? And the reality is you can't be a dual agent. It was a ridiculous solution. And there's almost nowhere in the country that allows dual agency anymore. And I believe it was about 6 years later, so the late 90s down here, the state of Florida did away with dual agency and it changed to transaction brokerage,
Right.
where you can choose to represent your client as a single agent, but the default is a transaction brokerage. Now, the general public still has no idea about that because as realtors, we've never done a really good job of explaining to them how we work.
Correct. Exactly.
And that kind of brings us to where we are today.
Brings us to where we are today. So obviously there were a couple of other changes that happened during that time where people really kind of freaked out about what was going to happen in the industry. One of the other
You mean
ones,
like Zillow?
Yeah, Zillow. When the National Association of Realtors agreed to enter into a contract with Zillow to share, it wasn't just with Zillow, but with any aggregator to share our data with them, putting the hands of our industry into someone else's hands. And then the financial crisis happened, and the way I'm going to talk about the one in the mid-2000s that happened, which really caused banking regulations for home buyers to change in a crazy substantial way, putting a lot more restrictions on how things were going to happen. And then COVID happened, and we had to pivot literally over the course of 2 weeks to change the way that we did business because the circumstances and the environment dictated a change had to be made. And then we come to today. And for the history of what this lawsuit actually is, so you know, this lawsuit has been in court since 2019. Prior to COVID is when this whole thing actually started in Missouri. And
just for
yeah.
one second.
Yeah.
What I want you to really pick up on and listen to what Scott was talking about, change is constant,
Yes.
especially in real estate. It changes all the time. As you know, even with the contracts that you use, look at the dates on the bottom left corner and you'll see those contracts are constantly being revised to reflect changes. Stop being afraid of change.
Yeah.
If you embrace it and understand what it is and how to work with it, as opposed to all those other people out there that are going, oh, this is going to be horrible, this is a disaster, how are we going to do this, we're never going to work with the buyer again. They're going to be gone in a while.
Yeah.
And if you embrace it and learn from this, you're going to be the ones left in the business
Actually,
succeeding
between
big
your
time.
2 years.
You got
Your
it.
thought process and your mindset says, I'm good. I can roll with change. I will adapt.
Correct.
As I have adapted over the years, right? has to be your attitude in order to survive.
Yep.
And the ones that don't have that attitude, goodbye.
So anyways, this lawsuit started in 2019, finally went to court in October of 2023. The case itself lasted about 12 days. The jury went to go and deliberated for less than 3 hours, came back and said, we find in favor of the plaintiffs in this case, and we're awarding $1.7 billion. To which everyone said, what the hell?
With treble damages, because
Correct.
it was a class action
Correct.
lawsuit.
Correct. And the person who litigated this entire thing was not experienced in the real estate industry to any extent.
He's
He was a
class
personal
action attorney.
injury attorney, and basically they went and formed a case because they had somebody come to them that said, hey, you know, I don't feel like I should have had to pay the buyer, Richard, and that was never clearly explained to me. And then they went and said, okay, well, if you feel that way, I think I should go and talk to this guy over here. You sold your house recently, right?
Yes,
Yeah, and did you pay a buyer agent?
I did.
Yeah, did you know that you were going to have to pay a buyer agent?
No, I did not.
You didn't. Okay, great. So that means two people have. And they went over here and said, hey, you sold your house recently, right? Yeah, and did you have to pay a buyer agent? So
No.
Did you know that? Did you know that you were going to have to do that? No, okay. So they built a case around saying that they didn't have to understand this. Well, contracts were also a little bit more loose in the state of Missouri. They weren't as clearly defined as they are here in the state of Florida. And it allowed them to put a case together, go in front of a court, and ask for class action status. And then there were a bunch of people that saw, okay, this is a class action case. I'd like to get involved in that. What is this ultimately going to look like? Which led them to going through it. One of the challenges with that whole thing is they had a judge who would not allow many of the pieces of evidence for the real estate companies to be presented in court because he ruled it irrelevant, although that's where the appeal process would have come in and many of those things would have been able to come to light at that point in time. But let's go into this. So the NAR press release said this: 2 critical achievements of this resolution are the release of most NAR members. I want you to remember that most part right there. Most NAR members and many industry stakeholders from liability in these matters, and the fact that cooperative compensation remains a choice for consumers when buying or selling a home. Keep in mind right there, it says remains a choice. It was always a choice. NAR also secured the agreement, a mechanism for nearly all brokerage entities that had a residential transaction volume in 2022 that exceeded $2 billion in MLSs not wholly owned by the realtor associations to obtain these releases efficiently if they choose to use it. So here's what I put. Ultimately, I believe that this is a positive thing for us to be able to move forward as an industry, simply because it takes this lawsuit and says, we're not focusing on that anymore, we've settled it, and we're going to move forward.
So when the judgment came out, shortly thereafter, Anywhere, which is the parent company of Coldwell Banker, Century 21, Sotheby's,
Better Homes and Gardens,
Better
all
Homes.
those, yeah.
They settled. They agreed to pay $75 million. About a month later, RE/MAX settled. They paid $55 million. And Keller Williams and NAR and Berkshire Hathaway all dug their heels in and said, we're not settling. We're taking this all the way. We know we're right. We know that if this is going to go to appeals, we're going to be okay. And then last month, a couple weeks before family reunion, word comes out Keller Williams settled.
For 75
Same
million.
thing, 75 million as well. The reason these companies settled, and there was a great article just this morning in the news feeds from the president of Anywhere, who was the first one. He said, we want to put this behind us. We want to be able to enable our agents to move on and work. That's exactly what happened with Gary. He looked at it and he said, listen, we can continue fighting this. We can tie this up for another 4 or 5 years in appeals. But we know things are changing.
Yeah, and one of the big things about that, Richard, is another lawsuit out of, I forget, it's either Massachusetts or New Jersey, where the Department of Justice has actually stepped in and said, we don't believe your settlement goes far enough.
Was the Mueller?
The Mueller case.
It was the DOJ
Yeah.
getting involved and actually reneging on an agreement that they had with NAR
With the last
from
few
2
hours
years
before
ago.
that agreement went into place.
Yeah, they said, no, we're not going to do this. We believe, and DOJ is the one that said they want commission to be totally separated.
Correct.
We want you to work as a listing agent, you get paid from your client. You work as a buyer's agent, you get paid from your client. That was their standpoint.
Correct.
So with that realization, this was NAR talking to DOJ, talking to the attorneys and said, listen, we've got to get this over with so our agents can move on.
Plus,
Everybody knew that this was going to happen. It's what the end result of all this was eventually going to be.
it allowed them to say, look, we're going to have a change, but instead of making change 2 different times in a major way, we're going to make one major change, and everyone will adapt and we'll get better for it. So let's go into the second part of this. NAR fought to include all members in the release and was able to ensure more than 1 million members are included. Remember, there's 1.6 million approximately realtors in the National Association of Realtors. 1 million of them are covered. Despite NAR's efforts, agents affiliated with Home Services of America and its related companies, which are the last corporate defendants still litigating the Setzer Burnett case, are not released under the settlement, nor are employees of the remaining corporate defendants named in the cases covered by the settlement. So that right there, those companies, the people who are affiliated with those companies aren't covered in this because that company has not chosen to settle anything because they were one of the named defendants in the lawsuit. So while NAR settled for everyone, it excluded them being able to settle for the agents who are members of those companies, which is why Keller Williams also had to have their own settlement as well, because we were named as a defendant in that lawsuit. In addition to the final payment, NAR has agreed to put in place a new MLS rule prohibiting offers of broker compensation on the MLS. This would mean that offers of broker compensation could not be communicated via the MLS, but they could continue to be an option consumers can pursue off MLS through negotiation and consultation with real estate professionals. Offers of compensation help to make professional representation more accessible, decrease costs for home buyers to secure these services, increase fair housing opportunities, and increase the potential buyer pool for sellers. They're also consistent with the real estate laws in the many states that expressly authorize them. Further, NAR has agreed to enact a new rule that would require MLS participants working with buyers to enter into written agreements with their buyers. NAR continues, as it has done for years, to encourage its members to use buyer brokerage agreements that help consumers understand exactly what services and value will be provided and for how much. These changes will go into effect mid-July. It also doesn't include MLSs that aren't fully owned by realtor organizations. I've got news for you. Every single one of the MLSs in this area is owned by realtor organizations. Basically, that is talking about Atlanta and a couple of other small places in the United States. But it does create a mechanism for coverage if they agree to change practices and pay a per subscriber fee to the settlement fund. NAR didn't say whether member dues would be increased to pay for the damages, yet it did say for 2024 they will not change, which existing agents have already paid.
Okay, so one of the things I want you to notice here, changes will go into effect mid-July, as you have 4 months before these changes happen. Mike's asking about how many people I got phone calls from. Well, some of the phone calls that I've been getting, that I scratch my head about, is I'm under contract now for a $4 million property that's not closing to this fall. How's that going to affect me?
Richard said, is it July?
I'm going, really? You've got a contract, right?
Yeah.
Phone calls from agents. I'm going on a listing appointment tomorrow. Do I have to change any of the paperwork we're doing? I am writing a contract. Guys, nothing at all is changing from what you've done for the next couple of months. We're going to be talking to you about what you should be doing to get ready for this, what you can put into place now, but understand, None of this is changing until mid-July. And the reason it's mid-July and not a specific date, because the way these lawsuits and settlements work is that once a settlement is filed, and even that is iffy, there's 150 days before it goes into effect.
Yeah.
So there's discussion now as to when it's filed, when the judge accepts it, or the attorneys accept it. That starts the clock ticking. So it will be somewhere in July that actually comes about. You'll find out about it long before, as soon as we have firm dates on it.
So Richard, this part right here, it says NIR has agreed to put in place a new rule prohibiting offers of compensation on the MLS. It's just on the MLS we can no longer offer compensation, correct?
So these are the two main parts of the agreement.
Correct.
Now realize this agreement is 128 pages.
Yeah, and it'll be right to sleep.
Yeah, other than Scott, no one else would read this. And Scott will write a 150-page rebuttal to it. But the two main parts are just this. It's the offer of compensation, and this one here, that any buyer will have to have a buyer brokerage agreement signed by their agent. How many of you are currently using buyer broker agreements?
Good.
I'm thrilled. 25 years ago, we used to teach buyer brokerage agreements, and every buyer agent on the Bass Group team was required to use that. It's like going on a listing appointment, and other than our one agent in Evansville who has no clue about listing agreements.
We're not going there, Richard.
You need to have representation for your buyer. If your buyer doesn't want to sign an agreement with you, why are you working with that person? Because they're basically telling you right up front, I'm going to screw you somewhere in this deal. We used to call it a loyalty agreement, and it was always looked at, didn't have a lot of teeth to it. You know what? It's a legal document, and if we want to pursue it, just like a seller who reneges on a contract, you'll call me, we'll talk about it, decide if we're going to pursue it or not. But without it, you don't have that ability. I just went through a mediation appointment yesterday with an agent with just this type of thing. If he had had that agreement signed with his buyer, he would have gotten the full commission. We ended up settling for a referral fee from the agent that did write the contract. It was a good deal for our agent. This is the biggest thing. Those of you that have been listening in on my listing contracts class, you know I am a huge proponent of single agency. I believe that you represent your client. It is not about representing the transaction, where you still have to do the right thing, but this is about being a fiduciary, putting your client first. And this is simply saying that if you're working with a buyer, you're putting the buyer first. Every agent will have to have that signed. So one of the worries was, well, you're telling the buyer that you want them to sign a buyer broker agreement. I'm not signing anything. I'll go find myself an agent that doesn't require this. Well, guess what? There ain't any agents out there that are going to require it. Jason?
So I'm just curious, if NAR is mandating that every buyer has to sign this
Correct.
to work with the buyer's agent, can the listing agent still be a transaction broker?
We don't know yet. There are a lot of unknowns to all this, guys. I have a lot of questions in my mind with what-if scenarios.
We still have more questions than we do
A lot
answers.
of this is going to come down to FREC. Now, I found out last week, was talking to somebody who's very active with the FREC committees, who's active on the MLS committees at the NAR level. And yes, FREC has been working on all new contracts. They work on it all the time. The problem with FREC is that they have about 24 attorneys that work for them reviewing all those contracts.
And everyone has a
And,
different
and
opinion.
try putting 24 attorneys in a room and getting them to agree with anything. So it takes a lot longer than it normally does. But they're already working on all of this stuff. I don't know the answers to. Here's one of my questions, Jason, that I'm looking at this and I'm going, this is NAR mandated. What happens to the agents that opt out of NAR? Because that's one of the agreements, is that we can no longer mandate agents belong to NAR. So if it's a licensee and not a realtor, do they have to abide by these rules? I don't know. It's going to come down to how the individual states set up their laws.
And speaking of that, Richard, you remember at Family Reunion when you and I were texting back and forth, and Gary was talking about buyer representation, and the number 40, I think it was 44% came on the screen. It said 44% of agents currently use some form of a buyer representation agreement.
Not agents. It was 44% of all buy-side transactions in the country.
Yes.
Was the transactions were done with buyer representation. So you understand, the state of Georgia, you have to have a buyer representation agreement signed. Massachusetts, you have to have a buyer representation agreement.
Texas.
Those are state laws. Texas, same thing. So it's mandated throughout the country already. Florida is just one of the states that never did it. So this is not a huge change in the industry. It's just a change for the people that weren't doing it.
And one of the things I'm going to work on bringing in is some great buyer's agents from those other states to do their buyer presentations for us, so that we can see how they've been handling it for years and years and years.
Yeah, which is skipping ahead, but this coming Monday, we are bringing in Jackie Ellis, who's my partner in the Boca Boynton office. She's also one of the handful of KWRI master faculty trainers, and one of her favorite classes is listing buyers. She's going to be doing her buyer presentation. It says this Monday at the Fort Lauderdale board in Wilton Manors. There are only 70 seats available.
We have 12 left.
We have 12 left. If you haven't signed up, guys, you better go and
Have you
sign
signed
up
up?
today.
Sign up at
Yes.
kwwaxman.com/live, and it's from 9 to 3.
Where can we sign up?
And then,
kwwaxman.com/live.
and then on Tuesday, Keller Williams has developed a new course called Value Squared. It's taught live by Gary Keller, Jay Papazon, and Jason Abrams. Okay, they're only doing it every couple of weeks. They did it 2 weeks ago. They're doing it again on Tuesday. We're going to be streaming that live right here. I recommend you can go on to Command and sign up for it individually.
Yeah, you
if you
can
want
do
to
it
watch
from
it
your
at
home.
home.
Yeah.
But I really recommend come on into the office, because when you're going to watch that, and that's from 1 to 5.
1 to 5.
The discussion that will be held among you afterwards will benefit you. Now, on Monday's call as well, they were telling us that from the first class they did to the one that's coming up this
They made a
Monday,
bunch of changes.
they've already made a whole lot of changes because of this ruling.
Yeah.
It's going to be focused a lot more on the buy side, how to show clients your value proposition.
Richard, I want to ask another question before we get to some of your questions. There's a couple of things I want to cover on this as well. So, an agent can still continue to offer compensation
Yes.
on their own website, correct?
We just cannot publish it in the MLS.
In any form.
Now, this is, one of the questions you're reading. Well, and the boards in the next while, that field is gone.
So that's immediate.
No,
July.
It goes into effect July. Whether the boards change it earlier or not, we'll let you know as soon as we hear anything.
Yeah.
But as of now, just think end of July. But those fields with compensation will be gone. So how do you tell other agents what you're going to be paying out?
Broken up.
Well, you've been hearing some people go, well, you can put it in the broker's remarks. Well, that's still part of the MLS.
Correct.
So does it apply or not? I don't know. That's just the way I'm looking at it. You can't put it anywhere in the MLS. I've been hearing some people go, well, everybody uses Showing Time these days, which happens to be owned by Zillow. We can put our commissions in Showing Time. So when you call up to set up a showing, you can ask what's the commission being paid out, and they'll tell you there. Guys, you can try and find end runs around this law any way you want, and I'm sure there will be some really creative ones. But the bottom line is you can't advertise what cooperative commission you're paying out.
In the MLS.
Now, does that mean that, Scott, you want to show one of my listings, you call me up and go, I want to show your listing tomorrow at 2 o'clock. By the way, what's the compensation on it? And I share it with you. How difficult is that? That's going to be the main way
And
that
then
this
Richard
is
will
relayed.
follow up and say, Scott, I'd like to get that in writing from you. I'm going to send you this form real quick. Go ahead and sign it for me.
Well, I don't care about getting it from him. He better care about getting it from me. I'm the
Fair
listing
enough.
agent.
Yeah, okay, there you go.
All right, so now, okay,
Look at you.
go ahead, Jim.
I just want to know, does that mean our office maybe can create some sort of portal where we can advertise?
Yes, it's one of the things that's being looked at. Because one of the exclusions of this is within a brokerage, the compensation can be shared. What KW is looking at is we have our own proprietary website, so every KW listing that's on our website could advertise the commission, theoretically. If you're RE/MAX and every RE/MAX is considered the same. Now, this is details. You know, brokerage is just this office. Fort Lauderdale's a separate brokerage. You know, each RE/MAX independently owned and operated. So it depends on how they look at that law. So they're going, well, you just go to kw.com and you'll see all the KW listings, so you'll know there. That's what I'm saying. There's a whole lot of ways people are looking at. Let's just give it some time to see how this settles out and what our boards and MLSs are doing.
Another thing that many people don't know was even going on behind the scenes. I mentioned it in our mastermind yesterday, but there was a program that Keller Williams, RE/MAX, Anywhere, Better Homes, or Berkshire Hathaway, and there was one other major company involved in it back in 2017, 2018. They were putting together something called Upstream, which would have allowed agents to go and put their listing into one place, and then from there, it would disseminate all of that information to the MLS and to the aggregators that they wanted it to go to.
It's like
So,
it's like a non-MLS MLS.
I know that program is just parked somewhere, and it is
Waiting.
very likely that it could be re-engaged quickly, because that organization that put it together is still a thing.
That Upstream is actually owned by
It's owned
all
by
of
those
those
companies. Yes.
There are, just hold on one second. There are, so you can't advertise it in the MLS. There are other ways.
Or you'll hear that sound.
You know, there are going to be ways to get this out to people. What this is saying is sellers do not have to offer any compensation to a buyer's agent. But that's actually been in place for a while now. You know, it used to be, and this was the clear cooperation policy from NAR that really started a whole lot of this, that says, if I'm a listing agent, I have to offer you compensation. And for a long time, you could put $1 in there. And a lot of you know, you go into the MLS and do searches, and for non-representation, you might see $1. Well, earlier this year, that was actually changed, that you could put 0 in there. They did away with the cooperation. They want to break this up even further, going, well, that's not even going to exist anymore. Seller doesn't have to pay anything. So you go on a listing appointment, and this was the conversation Mike and I were having. What's your conversation with your seller like? Well, Mr. and Mrs. Seller, first of all, a whole lot of them, even with all the ridiculous news headlines out there, still don't know about what's going on. But if they do, go, Mr. and Mrs. Seller, it's always been very typical in real estate, you know, and understand commissions are never fixed. They've always been negotiable by everybody. But the listing agent is the one that basically collects the money from the seller, and then we pay out a co-op agent who brings the buyer to the transaction. But that law has now been broken apart. And there are really 3 scenarios that you can use.
Write these down, this is
One,
important.
Well, there are going to be people who are much better at scripts and dialogues
And
than
that's
I am
okay,
teaching
right now,
this.
until we find those people,
But your
Richard,
three-
this one's good.
Okay, but your 3 options are, 1, you don't have to offer any compensation to the other agent.
Which, by the way,
And
Mr.
that
Seller
broke-
has always been your choice.
And that agent will then have to collect their commissions from the buyer. Now, the problem with that is most buyers out there don't have the extra money to pay their broker the commission, as well as paying all their other closing costs. And those monies are not financeable. So they can't roll that into their mortgage. And you guys are going to be dealing with that a whole lot in the next while, I'm sure. Which means there's going to be a whole lot fewer buyers looking at your house. Option 2, just as we've always done it in the past, we can make a full offer of compensation to the other agents. Or the third option is it's totally negotiable when they make an offer. Those are your 3 choices. Which of them would you like to go with? So I had an agent just yesterday who was saying, went on a listing appointment, they actually had that conversation. The seller says, well, how much is the commission? Says, well, the listing side commission for me is 3%. She said, and it's up to you as to what you want to pay to the buyer's agent. Seller says, well, why wouldn't I pay the buyer's agent the same thing that I'm paying you? So she got a full 6% listing, explaining to the seller how it actually works. That's going to be one of your, I'm not going to say challenges, this is going to be one of your jobs in the next 4 months, is to learn these scripts and dialogues for a listing appointment. And it really doesn't change a whole lot of anything. Now, I've been working for a while, Scott, and it started with the ALC in Fort Lauderdale. I am developing a customized exclusive buyer brokerage agreement for our offices. And with that, I have commission agreements, addendums, all of the other paperwork that go with that. Because I don't know when the state is going to come out with theirs. And
We want to be really proactive on this.
And I've never really been a big fan of the EBBA, like the FAR leases. I think there's so many gray areas in it, so I wanted to tighten it up a little bit. I've been collecting documents from some of the other brokerages out there, and Coldwell Banker in particular is one of the most intense law-written contracts I've ever seen, but there are a couple of good paragraphs in there that I stole and put into ours.
Yeah, we basically took the best of the best from a bunch of different places, gave it to our attorney and said, here's our vision.
Yeah. I was able to get a hold of all of the contracts, the paperwork from Georgia, and look at theirs, and they're almost as bad as Coldwell Banker, but it gives me some really good information as to what needs to go into it. I'm going to be asking the ALC in this office if they would take a look at all those documents as well. I'm asking for feedback from our top agents as to what they like about it, what they don't like, what they would suggest in the way of changes. And within the next couple of weeks, hopefully we can get all of that settled down and then turn it over to our attorneys to take a second look at and go, what do you think of this? Yeah. So we're working on all of that for
Could that
you.
potentially be used in lieu of whatever?
In lieu of the state.
Right. Yeah.
There has never been a restriction on brokerages creating their own custom documents. If you've ever gotten a contract from Kai's has their own contracts. They don't use the FAR book. Coldwell Banker has their own listing agreement. They don't use the ELS. We have always retained that right. We're going to start doing it now. Hold on, let me start back here. You've been very patient, thank you.
I know that the MLS is what we use to confirm as a binding document how much the commission is being paid out to the buyer's agent. If that goes away, and you have a seller who's still willing
When that goes away, it will go away.
like,
So you're
when
right.
that goes away, you still have a seller who's willing to pay the commission. How, as the buyer agent, which document and who signs it? How do you have it?
Yes, we'll get that to you. That's one of the documents I'm working on. We'll get that to you shortly. 2 ways of doing it. First one is it's a commission agreement that's signed by the brokerage, by the brokers of each company. So if you're representing a buyer, you would send this document over to the other agent that says, you know, I'm being paid X commission. You're agreeing to pay it to me. So that's where an agent that takes a listing agreement and the seller is saying, yes, I'll pay this out. And if it's a different number, they have to go back to their seller, or you're going to agree to this, change their document. But that's the agreement between us as agents. Now, it's always been available to you, and I've talked to you about this in the past. Even today, if you go into the MLS and you see an offer of compensation that, examples, is paying out 2%, and you're telling the other agent, well, I've got a buyer representation agreement with my buyer who's agreed to pay me 3%, will you pay me that full 3%? To your buyer, you're turning back, in your listing presentation, your buyer presentation, you're explaining to them how all of this works. This is what my commission is. However, I will do my best to collect that from the seller so that you don't have to pay it. And with their consent, I'll provide you with the paragraph. It goes into additional terms on the contract, and it basically say, buyer and seller agree that seller will pay X commission to buyer's broker's agent. You cannot use a contract to negotiate your commission because a contract is between the buyer and the seller. But that paragraph makes it a condition between the buyer and the seller that the seller is paying the buyer's agent's commission. You kind of get this? It's a whole lot of nuances, doesn't really change anything.
There's an extra step to the whole transaction process that's going to be added to it for you.
We will clarify all of this as this starts. This just happened on Friday.
Yeah,
today's Wednesday.
Yeah.
We're still,
96 hours in.
we're still working on all of this. We will get this moving forward.
So on the buyer agency agreements for us to sign with buyers. I can just imagine, right, how this is all gonna start. This is like a bomb to the buyer. The buyer wants to see a house.
It could be a bomb.
But wait, just let me hear.
Yep, go ahead.
Right, and then we're saying, well, I can show you this house. However, I have this buyer agency agreement that I would need you to execute prior to showing you this house, right? Can we meet in my office and have this meeting, do the value proposition? I got you, right? We still have to present an agreement that says X.
Mm-hmm.
Will there, in your agreement, have a clause that if seller doesn't pay X, that we would be willing to take the less, so that this way they're not like,
That's the basis of,
right? So
of the commission part of that agreement. It says, Mr. Seller, you're agreeing to pay me X%.
so long as the seller's paying
If the seller is agreeing to pay X%, you don't owe anything. If the seller is agreeing to pay X minus 1%, we can either try and negotiate that in the terms of the contract, or you're just agreeing to make up the difference between the two.
But
Now, the way I explain it to, just use the examples. It's a 3% commission, and the listing agent's offering to pay out 2.5%. Mr. Buyer, I'm not coming after you to collect the other 0.5%.
right, but the
I'll just
document that I'm
accept that
signing
as what it
says that I
is.
owe you the other half. So what I'm asking is there a way, since we're gonna have our custom agreement,
Mm-hmm.
is there a way that we can word it such that if Mr. Buyer, I want 3%, right? I'm the best thing since sliced bread, but this guy's only paying out 2%.
Which you are.
Okay, this guy's only paying out 2%. In the event I can't negotiate on my own behalf to get that extra point, look, between you and me, I'm not gonna charge it to you, but I still need you to sign this 3%. Or is there a way to word it in the paragraph that if seller
Same,
only
same,
willing to pay
you
two.
can put that into additional terms.
Yes.
The same way as in your listing agreement
Okay, so we
now,
can put that
a lot of
additional
people
term
write
then.
in, if I
We're
bring
gonna-
the buyer, I'll do it for a total of X%.
We're gonna give you the permission to make that decision on your own. One of the ways that I would handle this right now, I think you could spin this in a really positive way and say, hey, Mr. Buyer, Mrs. Buyer, I'm sure that you're hearing some changes have happened in our industry. And here's what that means for you. It means that I'm no longer guaranteed my compensation through the MLS. But here's what I'm going to promise to you. I'm going to ask you to sign this paper that says that I'm going to work for you for the percent that we've agreed to today. Yet, here's what I want you to know. Just as I'm going to be negotiating for you every single step of the way to get you the best possible deal for that home, I'm going to also be negotiating for myself to make sure that I'm compensated by someone other than you. And in the event that we find the perfect house for you.
I would change that just a little bit. I would take that I'm going to be negotiating for me as much as for you.
Correct.
I'm going to be negotiating on your behalf.
Yes.
So that you don't end up having to pay me directly at
Yeah.
closing.
Yeah.
We're going to get that money from the seller.
Exactly. There's going to be some scripts that you're going to put in there, but ultimately you want to make sure that they realize that the two of you are negotiating together to make sure that you're getting them the best possible deal, not just for the home, but they're helping you to be compensated by putting the language in the contract that allows them to make sure you're compensated appropriately. And I truly believe that the majority of the time, there will be a commission agreement made prior to you even showing that home because of the fact that so many listing agents have gotten so used to advertising commissions. There may be a few of them out there who are going to say, screw you buyers, I'm not negotiating any of that stuff. And then that's going to be a little bit different situation. But I think you can come across this, Richard, in a way that's really beneficial for the seller, as long as you're explaining it correctly and you're truly having a buyer consultation.
That was pretty good, by the way, Scott. That was on the fly. That was solid.
Now, you guys realize that there are brokerages out there that set what their agents charge.
Uh-huh.
If you take a listing that instead of getting the brokerage 3%, you take it for 2.5%, that 0.5% comes out of your commission after you're split at those companies. There's companies out there that charge transaction fees that go straight to the brokerage. They're not negotiable, and if the agent doesn't collect the transaction fee, it comes out of their commissions. I have always looked at this, and Keller Williams has always looked at this. This is your business. It's up to you as to how you negotiate with your client. It's just now, instead of negotiating with the listing side, you now get to negotiate with the buyer as well. I think this is a huge positive. A lot of you have always heard my soapbox in the past. I have always believed that you should be a single agent for the seller, you should be a single agent for the buyer, and as that, why should you allow some agent who sucks at knowing their value proposition set what you're worth?
Yeah.
You are the best trained agent out there. You are going to be the best trained agents out there in working with buyers. Get paid what you're worth.
The way that Sean said it yesterday in the mastermind was the thing that's always been intriguing about our industry that is going to change rather quickly is in our industry, we pay idiots and experts the exact same thing. And now experts are actually going to make more than the idiots out there. And there will be some changes that come along with it.
What are the implications for, so we always work in single agency as listing agents. And we choose to work as single agency in the buyer transaction. Now, everybody's gonna be forced into single agency on the buyer side.
We don't know yet, Mike.
If you have to have a buyer broker agreement.
Comes down to. The buyer broker agreement that I've been working on designing is the same as your listing agreement. It's default single agent with transition to transaction.
Yeah.
That's going to be our choice as to how we work with it. But it's going to depend on the state.
I was
With
thinking
these
about the
changes,
implications.
is the state going to do away with transaction
I
brokerage,
don't know.
except within that's the purpose of it. If you're representing the seller and you're representing the buyer, can you both be single agents or?
Well, so many firms don't want you, as we know, it's only Keller Williams that wants to work in single agency as a listing broker. And so many agencies don't want to work that way. I'm just wondering if
They're
they
gonna
might.
they're gonna be forced.
Or they gotta go by the wayside because they don't want the legal
Well, the
responsibility.
current Coldwell Banker buyer brokerage agreement that I got a copy of still has them as transaction brokers. This is gonna be, well, we have to wait and see what the state says, but I'm moving us in the direction of single agency, whether you're working with a buyer or a seller. Scott?
A scenario, a question, and a possible suggestion.
Great.
So,
They all work
this-
into a ball.
the scenario is Jay Cabot mentioned. You have a sign in the yard, or you have an agreement with Homes.com. Your listings, right? Your listings, your leads. You get a call, and we're in this July, August scenario. Can you represent that buyer? The answer for that now is, my question is, that's unknown, correct?
Yes, it's unknown as to whether the state's gonna force single agency or allow transaction brokerage. I don't know. The other scenario is that buyer walks into an open house, and one says, I love this house, I wanna write a contract on it. You're a single agent for the seller, just as right now, you can be non-representation for that buyer.
Right.
So understand, Mr. Buyer, if you don't wanna sign this agreement, I can still do the contract for you, but you need to be aware of the fact I'm representing the seller. You have no representation in this.
You're saying now or
Even
post July?
now.
No, now definitely, but
Now.
you're saying post July?
Now.
Okay. My suggestion or possibility is that we have some sort of internal cooperation with agents in Keller Williams that will be at the ready in a scenario like that, to sign them up under whatever fiduciary level is needed to be a fellow Keller Williams Coral Springs co-broker, cooperative broker in a situation like that where the listing agent could request perhaps a referral back.
This is what I was saying, the buyer brokerage agreement that we're working on right now defaults to single agency with the transition to transaction broker built in there. So that buyer walks into your open house or calls you, we need to sit down, we need to chat, let me explain to you some of the changes in real estate, how we're working right now. I need you to sign this document. You've now automatically created that transaction brokerage. That's the way I'm designing it. I don't know if the state is going to move forward with that scenario or not. I might be doing all of this for naught until they come out with their ruling and say, okay, this is.
And when you say state, you're talking Fred?
Yeah.
All right, thank you.
Yeah.
I have a question. Could we be using the commission agreement form? Is that, if we were to post-July, decide that we're gonna go, I call you, you have this property for sale, and you say, yes, I'm listing it and the seller is paying commission. Can't I just send you the commission agreement?
You sent him over the commission agreement.
Even before going under contract or anything, we've agreed, I'm coming to show the property based on this.
Correct.
Okay. So that will still be an option.
Right.
What I'm understanding, and
Before you say that, I want to respect everyone's time. Anyone needs to go, feel free to leave at any time. We're just going to open this up for questions for a few minutes, but feel free to leave at any time.
so, before we show a property, now we're gonna have to be sending, commission agreements before we even show it.
It's the way I understand it right now. I'm not sure how the state's gonna look at that, but yes, you wanna show 123 Main Street, you would send over a commission agreement to the listing agent that says they're agreeing to pay Keller Williams X%. It's for those representing buyers, yes, there are going to be an extra 1 or 2 steps involved in your job.
I just like, sometimes I see like 10
But this
houses.
is for your protection.
So this is also why doing the actual buyer presentation is going to be really important, because you want to make sure you're narrowing down what they're truly looking for before you go and show them everything under the sun.
Okay, 2 quick part question. Okay. So you guys stated that Georgia already does that buyer actual agreement. So what do they do whenever, does it become a transaction for transaction brokerage?
No,
What do they do?
Georgia still, I mean, as of now, Georgia still has the cooperative compensation in the MLS. Their document is just saying that I'm representing you as a client.
So
It has nothing to
so
do with
nothing
the
has
commissions
changed
now.
with it.
Well, the buyer agreement does address commission being paid to the buyer agent.
Correct. It's just a whole lot more detailed than what the Florida exclusive buyer broker agreement is.
Correct.
But it's the commission, as of now, in Georgia and in Massachusetts.
Has a breakdown, so it doesn't.
And one of the things that we're gonna bring to you guys is, our team leader in Fort Lauderdale and his husband both grew up in real estate in Massachusetts, where this has been the law for a long, long time. And they're going to be doing classes in buyer representation, teaching their buyer consultation as to how to explain it to people. So we've got agents within our group that have been doing this for a long time that are there to help you out with questions.
I'm gonna brush off my skills and show you how we did it in Texas.
The second part.
I was just gonna,
She had a second part to her question.
Sorry, I'll be very quick. Alright, so I know that obviously you've been in this industry forever, so,
Let me dust the dirt off you.
with the
It's
mortgage
from that
companies,
gunfight too. So-
you said it before, you said it, it's illegal for the commission of the buyer to go into the mortgage, loan, into the loan.
Currently.
Is it, so maybe, do you think that the banks actually will be able to speak, or FHA, conventional, and change that? Is that in
Bob,
talks? Have you heard?
Bob, what do you think?
Or
Bob
Brian?
Will's here?
Brian?
Ask your question again.
Yes, sir.
So,
Guys, this is your best mortgage broker that you never want to deal with.
Well, that's
Those of you that don't know him, Bob Wills from Supreme. Bobby's been having conversations with Patrick, who is the head of
Right.
Supreme for this area. What are you hearing from the Mortgage Bankers Association with making changes to their rules allowing commissions to be financed?
Nothing. So, and it's a big nothing burger at this point, so whether it's Fannie Mae or Mortgage Bankers Association, we're gonna let this play out. There is no changes till July, so we're gonna let the news come in, let us digest it. And then after July, we'll see what comes next. So as it relates to banking or even appraisals, there's nothing on the horizon at this point.
Yeah.
And I'll just give you guys a little tip. We had this thing called TRID about 4 years ago, which changed the mortgage business.
And I was gonna say that earlier, that everyone thought it was gonna be like, it was chaos when they changed from the HUD to the closing statement and all that.
Yeah, and so
And now it's nothing.
to that point, right? So a lot of lenders went all crazy. The news media, who's our
Yeah.
friend, right? They went crazy with the idea you can't close loans for 30 days.
You talking about this news meeting, Bob?
Bingo. And we just got in the room and we broke it down to its simplest forms and what our goal was. Because I think as people, we need to deconstruct things. What's your goal? Your goal is to create value, right? You have to create value. And that's just plain and simple. And customers will pay for value. And so we did the same thing with TRID. What do we want to do? We want to create value. We still want to close in 8 days. And we were amazed at how simple that really was.
Yeah.
So don't get in your own head.
No.
Don't create your own obstacles. This is going to be simple as long as you create value. It's like my dad. My dad had, something he was going on with his heart, and I sent him to a foot doctor.
Yeah, good call.
I didn't
You don't like your dad very much.
I sent him to a heart doctor. Right? I mean, so the biggest purchase anybody's ever going to make is a home, right? And so if I'm buying a home and you need to perform to the contract, you don't say that today. Start saying it.
Yeah.
Right? Buyers need to perform to the contract legally, yes, and you as a buyer agent are a professional to help them do that.
Yeah, in adding to what Bob's saying, the one place that you're going to have to really pay attention to over post-July is FHA and VA, because unless anything changes with their regulations, the buyer themselves cannot come out of pocket any money for your commission, because that is a requirement of FHA and VA
So the
loans.
non-allowable fee.
Non-allowable fee.
But the
exactly.
other thing to know about commissions, Hannah, is that we can't finance anything that's not collateralized. So if
Yeah.
it's not collateralized by hard property, we can't finance it.
So unless it's in the contract part of the price and given as a seller credit, the bank can't finance something that's not collateralized.
And that's one of your discussions that you're going to be having with your seller and with buyers. That if it becomes part of the contract, that the seller is going to pay those commissions, it stays on the seller's side of the closing statement, and it becomes financeable because the buyer is paying for the house. It doesn't matter what other monies come out of that side of the deal.
So here's one of the things that was asked of me the other day, and then I'll come to you, Dan, I promise.
Yeah, no,
one of the questions that was asked to me is, does this mean that we as buyer's agents will make less money? My response was, only if you want to.
Or more. It could mean that we can make more, right?
You could. You absolutely could.
You're in control of your own destiny now.
There's so many things like this out there scaring people, and this one right here, and this one right here, that there's so many questions that people aren't sure about. And only if you want to make less money will you make less money doing this. You get to negotiate on your behalf, on behalf of your clients, and at the end of the day, if we buried this down to its simplest form, commissions no longer able to be offered in the MLS. Commissions are not going away. How you make sure you get your commission is just going to change a little bit.
We will have new scripts.
Yes.
For sure.
Yes.
All right. We want to let you guys go and get back to work. Before you do, just one quick thing for you.
Oh, yes.
All right. So guys, because of this, one of the great benefits from NAR is they are giving you the ABR designation for free. This is a course, Accredited Buyer Representation. You can do it online. It's 10 hours. You go to realtor.org, the NAR website, and just put in ABR. It'll get you there. Guys, this is a fabulous class to understand the value you're going to bring to buyers and how to work with them. Now, both the Miami Board and the Beaches Board are also offering these classes live. Online, it's 10 hours. Live, it's a 2-day class. Both of the boards are offering this in a lot of different locations. My hallucination is that Keller Williams has more ABR designations than anyone else out there. This is the changing face of the industry. If you're going to work with buyers, to me, this is a huge benefit to have ABR on your business card after your name, to be able to explain to a buyer, this is one of the benefits of working with me over working with some other agent that you might have been talking to. I have been specifically trained